I have never worked with the NSA because I was a lawyer in North Dakota, but I've worked with DOJ and FBI a lot in my private career, and I appreciate everything you all do. And what I've always found is the very best agents, the very best lawyers are very cognizant of where the line is and what they can do and what they can't do. They also, the best and most aggressive ones, particularly I'm assuming in this area, will push the envelope in order to do something because that's your job. I don't discount that. I think that is actually appropriate. I think that's why it's our job and the court's job to set where that wall is. So you can keep running into brick walls and doing what you're doing to keep our country safe. But I do want to go back to something that Mr. Ratcliffe was talking about, and we were doing the context between this gathering or this type of information in criminal cases, and one of the things that was stated was that this happens a lot in criminal cases, ex parte, wiretaps, all of that. But I think one of the fundamental differences that we have is eventually I get it all as the defense attorney in a straightforward criminal case. I get it all. I get to go to Brady, I get to go to Carpenter, I get to go to all of those things. And that's what I think we miss sometimes in this, in how we deal with it. I know the difference between Carpenter and, essential real-time tracking of your actual location versus business record exceptions. And this is a perfect example, I think, of where we get to that. But do you know how many FISA-derived informations have been used in how many criminal prosecutions have come out of FISA warrants?
If you mean, I'm not sure what you mean by come out of the FISA warrant. If you mean, how many cases have we used FISA information in a criminal case? Including Title I FISA, Title III of FISA. So there have been many of those cases since the late 1970s when FISA was first adopted. It's not a massive number, but I wouldn't have an exact count of how many there've been, but there have been over the years many different cases. And
I would just, outside of everything, I've never wanted a half hour longer in my life to ask questions, but. And how do you transition the intelligence gathering? We've talked about Brady, and it's not the same, and I understand all of those things, but when you get into a criminal case, we always have a saying, right? Hard cases make bad law, and there's back and forth going on about the Carter Page case and all of that, but the problem, I think, with a lot of this is we only hear about the hard cases. We don't hear about a lot of other things. I'm all over the place because I have so many questions I want to ask. But how does the Woods review work?
I think I'll let Mike answer that.
Yeah. Sir, if I can go back to your original question and answer that.
Yeah.
So, and I think an espionage case is a good example of, oftentimes we use FISA to build that case, and then we bring that to a criminal conclusion. And as we build that case, we make sure that FISA, the information that we have to turn over that's relevant to that case, gets declassified to be turned over to the defendant.
So I have a question. Have you ever found existing criminal activity unrelated to what you were dealing with that's been turned over to law enforcement?
I don't recall.
Terrorist talking to a drug dealer would be how I would, just that specific fact pattern.
I don't have any specific background on that. Mr. Wiegmann might have some on that.
I'd have to get back to you and see how often that has come up.
Yeah. And that's where I think the conflict comes in for people who are not naive and understand how we want to keep our country safe, but actually really do care about how the due process clause and civil liberties apply once we end up in those situations.
Just to be clear again, if we are using that FISA, the product of that FISA in a criminal case, we have an obligation to give notice to the criminal defendant. They have then the ability to challenge the use of that FISA information in court. There's a process that's all set up in the statute, and that's been done many times, again, in these cases, typically terrorism cases, espionage cases, and the like.
In regards to the Woods process, agent starts drafting an application. Once he's complete, he sits down with the supervisor. They review it together, and in every fact, he has to be able to show the supervisor where he got that information from. All that material goes into a book for review.
And this goes back to, I think, what several people, Mr. Cicilline, Mr. Ratcliffe, were talking about. And we had said the amicus attorneys get all relevant legal information. I think some of us would be more, I don't care if they have the top classified clearance that we exist in the world, but what would be the problem with having somebody an amicus lawyer in all of these hearings at their onset?
So this was something that was considered back in 2015, and our judgment at that time, and I think it remains our judgment today, is that that would really slow down and bog down the process in the FISA court. If you had an amicus participating in every FISA application was an adversary proceeding, certainly if we had that in a Title III context where we're doing ordinary criminal wiretaps, having an adversary proceeding in every application would make the process untenable.
Follow-up? Thank you. And I don't necessarily see, I think the oversight part of this that I would be looking at is that I don't want them to have all relevant information. I want them to have it all and be able to review it and deal with those. I don't necessarily think it would potentially have to be adversarial in the hearing. I would just want them to be able to deal with that, because the consequences for withholding information or those types of issues really only come to bear if somebody finds it out, which is typically very challenging when there's only one part of this process being presented. So I think there's potential ways to do this that doesn't slow it down, that also holds people accountable for making sure it's being done correctly. And with that, I yield back.